Good afternoon. Welcome to Independent Sector's July monthly policy update. We have people filtering in, so we're going to give you all just a minute to get settled as we report on the latest and greatest policy developments impacting the charitable sector on this, the 31st of July. And we'll see maybe the last day of the congressional session. Uh, always some always some potential drama about that. We want to be respectful of your time and of our esteemed guests' time. So let's dive right in. Again, I want to welcome you to Independent Sector's July monthly policy update. I'm Ben Kershaw. I'm the Director of Public Policy and Government Relations here. I'm joined today by Jessica Cameron, our close partner at Washington Counsel Ernst & Young, by my government relations colleague, Travis Swanson at Independent Sector, and by a special guest, Professor Lloyd Hitoshi Meyer of Notre Dame Law School. He's an expert in nonprofits and election law, is going to talk through some really critical and very timely legal developments impacting nonprofit nonpartisanship. If you're joining us for the first time on an Independent Sector webinar, welcome. Independent Sector is a national membership organization representing charities and foundations and corporate giving programs who are working to ensure all people living in the United States thrive. This is a webinar, and as part of that, our lines are muted. We will pause periodically to answer questions. Please feel free to put them in the Q&A box at any point. General banter and comments are prohibited, even encouraged in the chat function. Please do your best to keep those separate so we can get to all the questions. Before we start, I want to respectfully acknowledge I'm joining you today from Washington, D.C. It is the ancestral home of the Piscataway people who are still in the area, working to reclaim their land and their traditional practices. Also, a lot of the places and buildings we inhabit in Washington, D.C. were built by enslaved people. So wherever you're joining us from, we are really glad to have you. It is, as always, a really critical and busy time for policy developments impacting the nonprofit sector. And we usually start these conversations with a look towards Capitol Hill and how laws might be getting changed through the legislative process. Today, we are going to start with, as I noted, a conversation with Lloyd Meyer, Notre Dame Law School, about the impact of a potential case that could have on nonprofit sector, churches and non-churches, and potentially far-reaching. So this is a case, and I won't steal Lloyd's thunder here, but this is a case about something that we often refer to as the Johnson Amendment. So, Lloyd, before we dig into legal minutia, could you give us a quick snapshot of what is the Johnson Amendment and why it's important?
Sure, Ben, and thanks for having me. So the Johnson Amendment was a modification of the tax-exempt law for charities introduced by then Senator Lyndon Johnson in 1954. And what it did was it added a condition for charities to be tax exempt under Section 501c3, what is now 501c3, of the Internal Revenue Code. And the condition is that the charity cannot participate in or intervene in a political campaign by supporting or opposing the election of a candidate for public office. And with one minor clarification, a couple of decades later, Congress has left the Johnson Amendment in place since then, so now for more than 70 years.
And how has it impacted the, sort of the operations of nonprofits and charities sort of on an everyday basis in the last 70 years?
So it has had a major effect because the potential penalty for violating the Johnson Amendment is loss of tax-exempt status, a so-called nuclear option when it comes to tax-exempt charities. And therefore, charities and the leaders have been very wary of violating the Johnson Amendment. Sometimes they've been too wary. A question I often get is, what does it mean charities can't be involved in politics at all? And the answer is no. Charities can talk about public policy issues. They can even, to a limited extent, seek to influence legislation. It's the supporting or opposition of candidates, which is the problematic activity. But it doesn't just mean endorsements. It also means basically doing anything else, so in maybe more indirectly to support or oppose a candidate who wants to get elected for public office. That's what charities can't do, and charities are very conscious that they can't do that, at least with charitable resources. Charity leaders can do it on their own. They just can't do it with the resources of the charity or through the charity's official communication channels.
It's gratifying to hear you remind people, not just of what they can't do, but what they can do. And I say that as a registered lobbyist who works for a 501(c)(3) charity. There is a lot that charities can do. And so there's a lawsuit in Texas right now that is, potentially about two churches, but could have a pretty significant impact. Can you tell us a little bit more about that lawsuit?
Yeah, so almost a year ago, the National Religious Broadcasters, two churches, and another religious organization brought a lawsuit challenging the Johnson Amendment. They said the Johnson Amendment is unconstitutional, both as applied to us, but also just generally, as applied to every tax-exempt charity out there. And they argued that it was a violation of the First Amendment's free speech rights, free exercise of religion rights, Fifth Amendment due process rights, because it's maybe unconstitutionally vague, and for religious groups, a violation of the Religious Freedom Restoration Act as well. And that lawsuit was sort of sitting there, a little bit back and forth, but as most litigation goes, proceeding very slowly, when something very unusual happened earlier this month. And what's unusual is that the IRS agreed with the plaintiffs that, in fact, they should win a portion of their lawsuit. And what the joint motion that the parties filed said is that we believe there's actually an exception to the Johnson Amendment. The exception is for churches or other houses of worship that engage in speech about candidates as part of their religious activities, so through customary channels to their congregations. And because there's this exception, we believe, that means as to the two churches in the case, they should be allowed to, engage in this kind of speech, and it's not a violation of the Johnson Amendment or federal tax law more generally. Now, the IRS has always had a sort of a hands-off approach to this area. As you can imagine, it's very politically sensitive. There have been a few times where they've been more active, but generally, they've left churches alone and other houses of worship when they've been engaged in electoral politics. At least, again, if it's from the pulpit to literally preaching to the choir, basically. And so the fact that the IRS wants to go soft in this sort of enforcement, that's not the surprise. What the surprise is the IRS is actually explicitly stating in this case that this exception exists. And frankly, their interpretation of the statute and there are other reasons for saying we believe this exception exists is pretty strained. It's a reach, especially under existing case law. But that's the position they're officially taking in the case now. Only technically applies to those two churches in the case. At least that's all the order they're asking for would apply to, assuming the court even accepts it. But it's a pretty strong signal, a stronger signal we've ever seen from the IRS saying, churches, if you do this, at least under the current administration, we will not seek to revoke your taxable status or otherwise penalize you.
So, as you note, this is a proposed settlement between these churches and groups and the IRS. Do you see implications for this decision beyond churches?
Not immediately, but perhaps in the future. And there was a question, someone asked, what exactly is the exception? The exception is it doesn't reach speech by a house of worship to its congregation in connection with religious services through its customary channels of communication on matters of faith concerning electoral politics viewed through the lens of religious faith. That's literally the language. There's a lot of caveats there, right? So as it's worded, this would only apply to churches or other houses of worship, temples, mosques, and so forth, synagogues. But there's two problems. One is technically the case only applies to those two churches, right? So it doesn't apply to any other church. No other church can rely on this as a legal matter. But more broadly, if you create this exception for churches, what about organizations that aren't churches? Or maybe they're similar to churches, but not quite. Does an atheist society, does an ethical society, are they a church? Can they take advantage of this? What about groups that are purely secular? Are they say, is this an establishment clause problem? Can you allow these kinds of charities to support candidates, but not us? And you could expect that if this exception, gains traction, other groups are going to argue, well, hey, what about us? This is actually unconstitutional to treat us differently than the religious groups, because now you're favoring religious groups over non-religious ones, and that's an establishment clause problem, First Amendment problem. So it could potentially undermine the entire Johnson Amendment, at least, again, in some exception that should apply more broadly than just churches.
You've been following, right, nonprofits and election law for, for some time. You have considerable expertise in this area. Is this usually how policy changes are enacted through court settlements?
No, this is very unusual for two reasons. One is the Johnson Amendment is a statute enacted by Congress, again, more than 70 years ago, modified only once in between to sort of just clarify its scope. And there have actually been repeated attempts in Congress to modify or even repeal the Johnson Amendment completely, including to create an exception sort of along these lines. And Congress has rejected every single one of those. So there's really a separation of powers concern here, that this is really Congress's statute, Congress's rule. Congress should be in charge of creating exceptions to it, and therefore the executive branch is overreaching here by creating an exception where the language of the statute, the IRS is arguing the language statute allows this exception or even requires it, but that's a real strained reading of the statutory language, particularly since for 70 years the IRS did not take that position. So that's one problem. The other problem is usually when the IRS is going to make a major policy change like this one, they would at least do something like a notice, or maybe a proposed notice, a proposed revenue ruling, proposed procedure, or even a proposed regulation, and get comment and get feedback from the public about this to help clarify. So we're thinking about this. What's the issues with creating an exception like this? What should be the parameters of this? And none of that's happened. And part of it also means that if the IRS does a notice or a revenue ruling, revenue procedure, or especially a regulation, everyone can rely on that. Every church in the country could point to that and say, okay, here's an exception. IRS has adopted it. We can rely on it. We are now safe from the IRS going after us, at least as long as that rule is in place. But a single pronouncement in a single case involving a handful of parties doesn't provide any legal protection for anyone else. And a new administration come in and say, that was wrong. That position was wrong. We're going to enforce the Johnson Amendment the way it's written. Oh, and by the way, we can do that against things that happened during the previous administration, because that ruling in that case only applied to those two churches in that case.
So, Lloyd, I know you noted that this action by the IRS was quite surprising, and so maybe predicting future actions is pretty difficult. But do you expect that there will be regulatory action taken along the lines of what you suggested was possible?
I think that's really hard to predict at this point for a couple of reasons. One is this was not complete surprise because the Trump administration, President Trump himself, has repeatedly said he opposes the Johnson Amendment, especially as it applies to churches, and referenced that a lot during his first term. Now, the only fruit of that in the first term was an executive order, which basically told the Treasury to enforce the law as it is, which really didn't change anything, but it was seen as sort of a signal that the Treasury should go, carefully when it comes to churches, which it already was, of course. Now they've issued this order, but to do the hard work of a notice and comment procedure or a formal pronouncement, that's a lot of work and effort. There are fewer and fewer bodies at the IRS and Treasury to do that work. And they have a lot of other things to do, like enacting, all the guidance related to the recently passed tax bill. So it's hard to know whether this is going to be a priority to do that. There's also, and I'm not saying that this was the motivation, but one aspect of doing it this way is it's easy to go back to groups that support this kind of exception and say, look, it's only in place as long as we're in power. So not that Donald Trump can run for another term, but if the Republicans aren't in power, or Republicans of the right kind aren't in power, this exception could go away because it's just a declaration in a court case. So if you want this exception to stay in place, you might want to think about who you want to endorse from the pulpit.
Lot of ramifications to consider. Thank you.
Right.
Lloyd, I want to take a couple questions from our audience. And you may see this first question about, noting that since houses of worship can only be C3s, but other organizations can become C4s, does that potentially guard against concerns that other types of nonprofits would seek exceptions to the Johnson Amendment?
So there are two big advantages having charities be able to violate or get around the Johnson Amendment. One big advantage is the tax benefits that charities enjoy that other types of tax organizations don't, particularly deductible contributions. And in the worst case scenario, what happens is I'm a rich donor. I want to support certain candidates, but I don't like just giving money to candidates and campaigns because I don't get a deduction for that. I give to a church, or another kind of charity, I can get a deduction for that. And if that charity, because I'm a large donor, decides to endorse a candidate because, hey, we want to keep our large donor happy, I've just basically laundered political money and made it deductible when I could otherwise not deduct it. So there's a big potential financial advantage, at least to large political spenders who use your charity. The other thing is a lot of charities out there, they may not have affiliated C4s, or the C4s may simply not have the PR clout that the C3 has. I mean, a lot of the best known nonprofits, right, are charities. And that name carries the clout. And this is particularly true for churches. This is actually one of the reasons why churches really want this exception, the ones that are politically engaged, because you can't preach from the pulpit with the C4. You have to do it with the C3. The pulpit is owned by the C3, and the message will not have the same impact if you go say, and now I'm going to go stand over in the C4 and send this message. And therefore, being able to do it through the charity and the platform of the charity and the communication outlets of the charity, that may be, frankly, irreplaceable.
You note that the endorsement or the brand name of the charity is particularly valuable. And I mean, that's one reason why independent sector and so many others are so concerned about erosion of this separation between charities and partisan politics. That trusted status, we believe, is not accidental. In fact, it's fundamentally tied to our separation from partisan politics, undermining public trust in our sector. And, I guess one thing I would note, Lloyd, before we turn to this last question, sort of related about C4s, is that this speculation that money would flow into partisan politics through tax deductible contributions is not just, idle speculation. In 2017, when this was considered legislatively, such a proposal scored as costing the US Treasury $2 billion, meaning, in the range of $6 billion was projected by the accountants, the nonpartisan accountants in Congress, to become newly deductible campaign spending. So that's right. That's not registered lobbyists talking, or college professors. These are the accountants within Congress. So certainly something to watch for. Look, do you have time for one last question?
Certainly.
Thank you. So question is about, we mentioned C4s. Could you remind people exactly what the limits for C4 nonprofits are around political candidate campaigns?
Sure. So 501c4s, which are tax-exempt social welfare organizations, don't get deductible contributions, but in exchange for that, they aren't subject to the same restrictions as charities. And in particular, the IRS position is that while they primarily have to engage in social welfare, which does not include supporting or opposing the candidates, they can support or oppose candidates as long as it's not their primary activity. Their social welfare activity is primary. Now, Where the exact line is, there's a lot of debate among practitioners and others about this. And Congress has prevented the IRS from issuing guidance on exactly where the line is for now a number of years. But the aggressive position would say as long as you spend 51% of your money and time and so forth on social welfare stuff, you can spend 49% on supporting or opposing candidates. And so you can do a lot of supporting opposing candidates through C4s. But again, anyone who gives to C4, they don't get a tax deduction for that.
Big difference. Um, Lloyd Meyer, I want to thank you again for joining us. And I would note for folks that we did share an article that Lloyd has published about this particular piece. So there are more details and more links there. Again, thanks for your partnership and your ongoing work on this issue and on our sector, Lloyd. Thanks again.
Thanks for having me.
I want to turn to Jessica Cameron with Washington Counsel Ernst & Young. As I noted, today is July 31st, meaning that tomorrow is August and Congress is supposed to be gone. They haven't had quite as orderly an exit as they sometimes do. So Jessica, could you maybe give us a little bit of a snapshot of where things sit on Capitol Hill right now on issues impacting the charitable sector?
Yes, thanks so much, Ben, and thanks for having me. And thank you, almost August recess, to those who celebrate. I know a lot of you have been working very hard, particularly on tracking the reconciliation bill that passed earlier this July. And I think it's safe to say that we all need a bit of a break. But we'll see if that actually happens today. So, the House last week already braked for its August recess. It'll come back after Labor Day, in the Senate is in this week. They have been primarily focused today on nominations. And one thing that now that reconciliation is done, Congress is starting to turn or start to chat about what appropriations looks like this fall. As a reminder, government funding runs out on September 30th, and so not too far away from when Congress gets back from its August recess, potentially. And the general thinking at this point is that potentially, if Congress does move forward with government funding, it may look like something like a continuing resolution or a temporary funding patch. There's a couple of reasons for this, but certainly one thing to note is that for a CR, Democrats will likely need to reach or Democratic votes will be required in order to reach a 60 vote threshold in the Senate. And as you can probably tell, we went through a pretty partisan process with reconciliation, as well as a rescissions package that was not too popular with Democrats most recently. There's also been some talk by the administration of having additional rescissions packages, and so that all of that has really clouded the debate on kind of what it looks like from appropriations going forward, and what that looks like. As kind of a semi-positive move, the Senate last week started the MilCon kind of procedural vote to start that package. That's historically been a package that receives more bipartisan support than not compared to other pieces in the appropriation space. So we'll see kind of all this plays out. I think it's too early to say that we are on a government shutdown watch, but I do think that we're watching this very carefully, and we'll watch it very carefully when we get back from August recess in terms of kind of what that looks like. But I think bigger picture, that's the focus for the fall, or at least the start of the fall, when folks get back. Now, what does the rest of the year look like? Certainly, the reconciliation package, if you've been on prior calls, I've was pretty skeptical that Congress or that Republicans would be able to pass the reconciliation package, or OB3, by July 4th. They ended up passing that package early, and so at the moment we are not going through those debates because that already happened. So what does that look like? I think some general statements in terms of where Republicans are. Certainly, I think Republicans feel pretty bullish in terms of possibly doing a second reconciliation package this fall, or at least they've very much started to talk about what that looks like, and what the broad contours of it could be. And I think that's partly because they were able to get the first reconciliation package done so quickly mid-year. I think the bigger question is, if they do reconciliation, what actually gets into this bill? I think there's some real questions about that. Now, certainly, I think I have some ideas, and I know Ben has some ideas that we come up with to benefit the charitable sector, but, I think let's kind of talk a little bit about what those pieces could look like. In terms of kind of anchoring a package, whether it's something like a second reconciliation package or a bipartisan tax and other kind of provisions package at the end of the year, the main driver of this would be the Affordable Care Act's enhanced premium tax credits. Those expire at the end of the year. These are the tax credits that reduce premiums for individuals above 100% of the federal poverty level who purchase coverage on exchange markets. So a pretty big deal. Now, these are typically Democratic, or this has traditionally been a Democratic priority, but given their weight, it's something, and also the fact that next year is an election year, a lot of Republicans are concerned and very much focused on kind of what that looks like and potentially putting those in a bill. So I think from a perspective of what does a bill look like, those are really what's anchoring that the possibility of reconciliation or something moving forward, as well as a number of other healthcare items. So it's largely starts out as a healthcare bill. There's also some potential trade issues, but on the tax side, we are hearing more and more from Speaker Johnson, from his staff, as well as from Chairman Jason Smith on Ways and Means, that there potentially could be some tax items in that bill. And I think that's where things get a little fun, a little spicy, because I think the question is, what does that look like? Again, they did a huge reconciliation package, not just a few weeks ago. And so what else do they have to kind of look forward to? I think the one I would flag for this group is certainly the work opportunity tax credit, extending those provisions. If you remember, those have a number of different buckets of potential individuals that could be helped, or employers that could be helped by certain individuals in certain fields. And one of those is veterans, which does apply to nonprofits, and a few other cats and dogs that could potentially get into that bill, but nothing kind of that rises to the level where it needs to get done at the end of the year, or at least is equivalent to kind of what we're seeing with the ACA premium tax credits going forward. So we're watching that very closely to see kind of what that looks like, what otherwise is included. And I think more importantly for this group and for the rest of our clients, we're looking at, if this moves forward, do they need to pay for it? And how would they pay for that going forward? So lots of questions still left unanswered that we're going to watch really closely. Finally, before I turn it back to Ben, I'll just say that there's obviously taking a step back, that now that reconciliation is done, Treasury is left to write a whole host of regs to address a number of provisions in the One Big Beautiful Bill. And so they'll start getting to work on those pieces. Where I would flag for all of you is that certainly this bill had focused mostly on the individual side. And so if you, for example, work with individuals that are returning to work, that work in the service industry, there are a lot of regulatory items that that Treasury is planning to tackle. So for example, I would just note that Trump accounts, that's the provision that provides $1,000 to children born between July of this year and the next several years. Looks kind of like a custodial account, kind of like a traditional IRA, kind of like a Roth IRA. Certainly a lot of questions around how those are set up. Expect regulatory guidance on that. So something to flag for any folks that deal with expecting parents. Additionally, for the provision of no tax on tips, which has a end limit on it, certainly some questions in terms of what the occupation list looks like and who would and would not qualify. And then finally, I'll just flag the tax credit for contributions to scholarship granting organizations. That's going to be a whole regulatory regime that Treasury is going to have to look at. So lots of things on the regulatory side that maybe the communities you serve aren't necessarily focused on, but certainly the practitioners and all of you may be very curious about. So watch out for a lot of that guidance. We're certainly tracking that very closely. I'll stop there, but we'll kind of see how the next few weeks shake out. And I'll turn it back to Ben.
Thank you, Jessica. Lots to dig into, and we will invite people to offer questions in the Q&A box. Let me ask you one sort of maybe bigger picture question. You talked about a reconciliation bill or a bipartisan bill. I remember the last time a reconciliation bill was passed, under Republican control, there are a lot of things people agreed ought to get fixed, and a lot of debate about whether Democrats would be part of any fixes to that bill, or whether they, wanted to make the bill as unpopular as possible, and so they weren't going to play ball, to be brief. So are you getting a sense that Democrats will take a different posture this time around? You're muted, sorry.
Thanks, Ben. It really depends on who you talk to. So when you talk to Republicans, ironically, I think they're open to the idea, certainly, of doing a second reconciliation bill, but they're also, I think, optimistic about either doing reconciliation or doing a bipartisan bill. Now, if you talk to Democrats, the folks that are needed to make that piece bipartisan, they're maybe not as interested in working on a bipartisan basis. And can't say I can blame them because you saw this a very partisan bill move forward with reconciliation. So we'll see how that goes. Typically, however, both sides have historically had a number of provisions of cleanup items, of technical corrections, of things that are not so much kind of rise to the level of material items, but certainly really important to the code that they would like to get passed. And we really haven't seen kind of those technical correction cleanup bills move forward in the last couple of years. I'll also note that, one, of course, is the possibility of doing a bipartisan bill would hinge on whether those corrections get done or some of those cleanup pieces get done. But also, if a second reconciliation bill is kind of the route that Republicans take, remember that there are some limitations in terms of the Byrd rule, in terms of what you can and cannot put in. And so a lot of those kind of cleanup pieces that folks have been talking about were kind of automatically off the table for reconciliation, and would still be off the table for reconciliation if that's the path they go this fall and into early next year.
Yeah, thanks, Jessica. And you make a really good point, right? We've seen a lot of the talk about doing another reconciliation bill is from members who were mad about changes that the parliamentarian made, which of course would be an issue in another reconciliation bill as well. So that's
exactly.
Yeah. So right, reconciliation has consumed, a lot of our time and effort as a sector, and we do want to make sure people see the summary of what tax changes were enacted, published by Independent Sector. Again, that's the bill that was enacted on July 4th, as Jessica noted. There are a lot of other issues popping in Congress right now that also impact the work of the charitable sector. And I want to turn to Travis now for an update on those issues. Travis, thanks again for being with us.
Yes, thank you, Ben. So I want to briefly highlight a promising bipartisan effort to support the nonprofit workforce. Last week, a bipartisan group of lawmakers from both chambers introduced the Small Nonprofit Retirement Security Act. This bill is designed to help small nonprofit organizations offer retirement plans to their employees by extending key tax incentives that right now are only available to for-profit employers. The legislation was introduced by Senators James Lankford, Republican of Oklahoma, and Catherine Cortez Masto, a Democrat of Nevada, and Representatives Vern Buchanan, a Republican of Florida, Jimmy Panetta, a Democrat of California, Blake Moore, a Republican from Utah, and Brad Schneider, a Democrat from Illinois. And what this bill does is it addresses a longstanding inequity by allowing nonprofits to apply for existing Secure Act startup tax credits against their payroll tax liability. Now, this matters because nonprofits don't pay income tax, so many of the current incentives for things such as offering retirement plans are out of reach to them. By making this simple fix, the bill would make it far more feasible for smaller organizations to provide retirement plans to their employees. This could mean up to $5,000 per year in startup credits, plus an additional $500 annually for automatic enrollment. Nonprofits employ nearly 10% of the US workforce, and ensuring that they have access to the same retirement tools as the private sector is a matter of fairness, and it's critical for long-term workforce stability. So independent sector, we've already been up on the Hill advocating for new co-sponsors on this bill and hopefully ultimately the bill's passage. We're obviously very encouraged by the bipartisan support that it's received in its introduction and are continuing to push it to try and get it across the finish line. Next, I'd like to raise a growing concern facing the nonprofit workers in regards to their student loan debt. The growing instability of the federal loan forgiveness program is threatening to undermine the trust of the workforce as well as retention, as well as just the basic fairness that these programs were designed to uphold. As many of you are aware, the Public Service Loan Forgiveness Program, or PSLF, is a bipartisan law that was passed in 2007 to ensure that student loan borrowers working in public service, including in 501c3 nonprofits, could access loan forgiveness after 10 years of qualifying payments. The law is very straightforward. If you work for a qualifying nonprofit, your service counts, regardless of that organization's mission. But now that certainty is at risk. The Department of Education is expected to very soon propose a rule that would let it disqualify some nonprofits from the PSLF program based on the type of work they do. So this includes very vague and troubling language to start this new standard around what substantially legal activity means, and it's a classification that could easily become politicized. If enacted, this rule wouldn't necessarily just apply to future employment. It could go a step further and even retroactively disqualify payments that were already made by borrowers who relied on the rules in place at the time of their payments. That would be a betrayal of public trust and a potential disaster for nonprofit professionals who have made life decisions based on the promise of this program. And it's not just PSLF that's under threat. Last month, the Washington Post reported that the Department of Education abruptly suspended loan forgiveness under the long-standing income-driven repayment plan. So this is a plan that forgives debt, student loan debt after 20 or 25 years, depending on the plan you're in, of repayment. This suspension happened with no explanation, no warning, and no timeline for when it will resume. This has left tens of thousands of borrowers in potential limbo after making decades of payment and knowing that their forgiveness should be happening. Independent sector strongly opposes these efforts to rewrite PSLF rules or any forgiveness pathway in a way that undermines trust and penalizes nonprofit workers for the nature of their service. The law already provides a process to remove organizations that violate the rules. The IRS can revoke 501c3 status for organizations not in compliance with those rules, and having that status revoked would disqualify PSLF eligibility. There's no need to create a new parallel system with vague standards and the potential for political interference. So we are continuing to closely monitor the department's proposal, which is not yet out, so it's a kind of forthcoming still. When the public comment period opens, we are definitely going to be alerting the sector and sharing opportunities to weigh in, whether that be if people wish to testify or sign on letters. Borrowers, especially those who have spent years serving their communities, deserve better than this uncertainty, and we're committed to defending their rights and the integrity of these critical programs. And then lastly, I just wanted to highlight a troubling development on the Hill that should concern all of us working in or alongside of the nonprofit sector. In mid-July, so just a couple of weeks ago, 2 congressional hearings placed nonprofit organizations directly in the political crossfires in the House of Representatives. On July 15th, the House Judiciary Subcommittee on Oversight held a hearing titled "How Leftist Nonprofit Networks Exploit Federal Tax Dollars to Advance a Radical Agenda." And the very next day, the House Homeland Security Committee held a hearing titled "An Inside Job: How NGOs Facilitated the Biden Border Crisis." As these titles suggest, these were not balanced oversight efforts. These were instead, they relied heavily on partisan rhetoric. They appeared designed more to discredit politically disfavored nonprofits than they did to foster meaningful accountability or policy discussion. This reflects a deeply concerning trend. The increasing increased politicization, sorry about that, of the nonprofit sector that we're seeing. When public service organizations become targets simply for their missions they pursue or the communities they serve, we risk undermining a fundamental part of civil society. To their credit, some committee members did speak up. They made very clear that during both hearings that they support the right for nonprofits to exist, even when they disagree with the work that they're doing. A lot of members pointed out that nonprofits are all across the political spectrum, and some of them are doing work that they don't agree with the mission, but they do have a right to exist, and not only a right to exist, but a right to operate without fear of political retaliation. Unfortunately, we expect more hearings of this nature in the months ahead. And at IS, we are working with our partners and the PSLF coalition, or sorry, not the PSLF coalition. We're working with our partners and watching closely and speaking out when necessary to defend the sector's independence, integrity, and our vital role in democracy. So these hearings, as I said, these were just two, but we do expect more of these kind of hearings to come later. And unfortunately, we are seeing the sector becoming more politicized in this Congress, particularly in the House. We have not seen any of these types of hearings in the Senate as of yet. That doesn't mean that they won't pop up. Some of these pop up pretty quickly, sometimes with very little notice, but we are constantly monitoring these things and watching them when they come up. So
Thank you.
that is all I have. If there are any questions, happy to turn the mic back to Ben.
Thank you, Travis. And yes, we would invite those questions. So, I think it's really interesting bookends to our conversation today, talking with Lloyd about allowing certain charities to endorse political candidates and politicize our sector. And then, right, means some real world implications of people politicizing our sector in those hearings. And as you know, Travis, those aren't legislative markups, advancing policy proposals, but they can become that pretty quickly. So if people want, so here's two action items for you all on this, on where we are right now. If you want to help protect nonprofit nonpartisanship, there is a sign-on letter to do that, and we will drop that in the chat. Independent sector has been co-leading this sign-on letter to the Trump administration, expressing concern about efforts to walk away from this firewall between charities and partisan politics. We've been co-leading that with National Council of Nonprofits and the Interfaith Alliance and other core partners. I know that's over 1,000 signatures right now from all 50 states, but we do need to continue to build support for that letter, so please do join. And then also, if you want to help enact the tax credit legislation Travis mentioned for charities and nonprofits to start retirement plans, we have an action in our Action Center where you could help build support for that. Contact your legislators with just a few clicks. So we don't want to turn you off to August recess on a downer. There's lots we all need to do and lots we can do to help the work of our sector and the communities we serve. I don't see that anyone has put questions into the Q&A box during my soliloquy. So we're going to give people, I think, just a moment. Again, I want to thank you for joining us this afternoon. Thank you, Travis. Thank you, Jessica. Thank you, Lloyd. Thank you, Manuel, for your work bringing us all together. we know that this has been a long and grueling summer for policy advocates in the nonprofit sector. And there is certainly plenty of work to do. But if August is the time when you usually rest, we hope you will get that rest this month, this coming month. We're going to need it, and we're going to need to be ready and refreshed. So thank you all again for joining us. Have a good break. We will see you back on this line in September. Take care all. Thanks again.